United Nations Convention on the Law of the Sea. 1982. Part 4. Archipelagic States. Article 46. Use of terms. For the purposes of this convention. A. Archipelagic state means a state constituted wholly by one or more archipelagos and may include other islands. B. Archipelago means a group of islands, including parts of islands, interconnecting waters and other natural features which are so closely interrelated that such islands, waters and other natural features form an intrinsic geographical, economic and political entity, or which historically have been regarded as such. Article 47. Archipelagic baselines. 1. An archipelagic state may draw straight archipelagic baselines joining the outermost points of the outermost islands and drying reefs of the archipelago, provided that within such baselines are included the main islands and an area in which the ratio of the area of the water to the area of the land, including atolls, is between 1:1 and 9:1. 2. The length of such baselines shall not exceed 100 nautical miles, except that up to 3% of the total number of baselines enclosing any archipelago may exceed that length, up to a maximum length of 125 nautical miles. 3. The drawing of such baselines shall not depart to any appreciable extent from the general configuration of the archipelago. 4. Such baselines shall not be drawn to and from low tide elevations, unless lighthouses or similar installations which are permanently above sea level have been built on them, or where a low tide elevation is situated wholly or partly at a distance not exceeding the breadth of the territorial sea from the nearest island. 5. The system of such baseline shall not be applied by an archipelagic state in such a manner as to cut off from the high seas or the exclusive economic zone the territorial sea of another state. 6. If a part of the archipelagic waters of an archipelagic state lies between two parts of an immediately adjacent neighboring state, existing rights and all other legitimate interests which the latter state has traditionally exercised in such waters and all rights stipulated by agreement between those states shall continue and be respected. 7. For the purpose of computing the ratio of water to land under paragraph L, land areas may include waters lying within the fringing reefs of islands and atolls, including that part of a steep-sided oceanic plateau which is enclosed or nearly enclosed by a chain of limestone islands and drying reefs lying on the perimeter of the plateau. 8. The baselines drawn in accordance with this article shall be shown on charts of a scale or scales adequate for ascertaining their position. Alternatively, lists of geographical coordinates of points, specifying the geodetic datum, may be substituted. 9. The archipelagic state shall give due publicity to such charts or lists of geographical coordinates and shall deposit a copy of each such chart or list with the Secretary-General of the United Nations. Article 48. Measurement of the breadth of the territorial sea, the contiguous zone, the exclusive economic zone and the continental shelf. The breadth of the territorial sea, the contiguous zone, the exclusive economic zone and the continental shelf shall be measured from archipelagic baselines drawn in accordance with Article 47. Article 49. Legal status of archipelagic waters, of the airspace over archipelagic waters and of their bed and subsoil. 1. The sovereignty of an archipelagic state extends to the waters enclosed by the archipelagic baselines drawn in accordance with Article 47, described as archipelagic waters, regardless of their depth or distance from the coast. 2. This sovereignty extends to the airspace over the archipelagic waters, as well as to their bed and subsoil, and the resources contained therein. 3. This sovereignty is exercised subject to this part. 4. The regime of archipelagic sea lanes passage established in this part shall not in other respects affect the status of the archipelagic waters, including the CO lanes, or the exercise by the archipelagic state of its sovereignty over such waters and their airspace, bed and subsoil, and the resources contained therein. Article 50. Delimitation of internal waters. Within its archipelagic waters, the archipelagic state may draw closing lines for the delimitation of internal waters, in accordance with Articles 9, 10 and 11. Article 51. existing agreements, traditional fishing rights, and existing submarine cables. 1. Without prejudice to Article 49, an archipelagic state shall respect existing agreements with other states and shall recognize traditional fishing rights and other legitimate activities of the immediately adjacent neighboring states in certain areas falling within archipelagic waters. The terms and conditions for the exercise of such rights and activities, including the nature, the extent and the areas to which they apply, shall, at the request of any of the states concerned, be regulated by bilateral agreements between them. Such rights shall not be transferred to or shared with third states or their nationals. 2. An archipelagic state shall respect existing submarine cables laid by other states and passing through its waters without making a landfall. An archipelagic state shall permit the maintenance and replacement of such cables upon receiving due notice of their location and the intention to repair or replace them. Article 52. Right of innocent passage. 1. Subject to Article 53 and without prejudice to Article 50, ships of all states enjoy the right of innocent passage through archipelagic waters, in accordance with Part 2, Section 3. 2. The archipelagic state may, without discrimination in form or in fact among foreign ships, suspend temporarily in specified areas of its archipelagic waters the innocent passage of foreign ships if such suspension is essential for the protection of its security. Such suspension shall take effect only after having been duly published. Article 53. Right of archipelagic sea lanes passage. 1. An archipelagic state may designate sea lanes and air routes thereabove, suitable for the continuous and expeditious passage of foreign ships and aircraft through or over its archipelagic waters and the adjacent territorial sea. 2. All ships and aircraft enjoy the right of archipelagic sea lanes passage in such sea lanes and air routes. 3. Archipelagic sea lanes passage means the exercise in accordance with this convention of the rights of navigation and overflight in the normal mode solely for the purpose of continuous, expeditious and unobstructed transit between one part of the high seas or an exclusive economic zone and another part of the high seas or an exclusive economic zone. 4. Such sea lanes and air routes shall traverse the archipelagic waters and the adjacent territorial sea and shall include all normal passage routes used as routes for international navigation or overflight through or over archipelagic waters and, within such routes, so far as ships are concerned, all normal navigational channels, provided that duplication of routes of similar convenience between the same entry and exit points shall not be necessary. 5. Such sea lanes and air routes shall be defined by a series of continuous access lines from the entry points of passage routes to the exit points. Ships and aircraft in archipelagic sea lanes passage shall not deviate more than 25 nautical miles to either side of such access lines during passage, provided that such ships and aircraft shall not navigate closer to the coasts than 10% of the distance between the nearest points on islands bordering the sea lane. 6. An archipelagic state which designates sea lanes under this article may also prescribe traffic separation schemes for the safe passage of ships through narrow channels and such sea lanes. 7. An archipelagic state may, when circumstances require, after giving due publicity thereto, substitute other sea lanes or traffic separation schemes for any sea lanes or traffic separation schemes previously designated or prescribed by it. 8. Such sea lanes and traffic separation schemes shall conform to generally accepted international regulations. 9. In designating or substituting sea lanes or prescribing or substituting traffic separation schemes, an archipelagic state shall refer proposals to the competent international organization with a view to their adoption. The organization may adopt only such sea lanes and traffic separation schemes as may be agreed with the archipelagic state, after which the archipelagic state may designate, prescribe or substitute them. 10. The archipelagic state shall clearly indicate the axis of the sea lanes and the traffic separation schemes designated or prescribed by it on charts to which due publicity shall be given. 11. Ships in archipelagic sea lanes passage shall respect applicable sea lanes and traffic separation schemes established in accordance with this article. 12. If an archipelagic state does not designate sea lanes or air routes, the right of archipelagic sea lanes passage may be exercised through the routes normally used for international navigation. Article 54. Duties of ships and aircraft during their passage. Research and survey activities, duties of the archipelagic state. And laws and regulations of the archipelagic state. Relating to archipelagic sea lanes passage. Articles 39, 40, 42 and 44 apply mutatis mutandis to archipelagic sea lanes passage. To be continued.